Welcome back to Chocostable Media. This is the
Thank you
part
so
two.
much.
Let's
And
go.
yes, so generally, what a will does in terms of being able to simplify the asset distribution process is that a will generally is considered a legal document which allows you to put together how you want your assets to be distributed through specifically named beneficiaries. And because we say a will is ambulatory, it takes effect only upon the demise of the testator. The testator is the one who writes the will, right? And the beneficiaries are his dependents who take benefits from the will which is accrued to. The subject of it are his assets. And as Dr. Sophia mentioned earlier, asset costs through a wide range of many things, whether it's real estate, money in the account, equities, intellectual properties like patents, like trademarks, jewelries, physical belonging, cars. All of these things are assets that should be specified. And oftentimes, when you draw up a will, you want to be able to ensure that those wills, all those things are detailed down. Who can make a will? Anyone who is of a sound mind, who's an adult, right? Once you're 18 years old or 21 in Nigeria, you're an adult and you're capable of making one. The law also requires that whoever is making that is deemed to be in a sound mind. You're in your sound mind. You're not insane. You're not mentally derailed. You know what you're doing. And those are things that those are things that you may want to specify towards that. Intention is also very clear in terms of how you want your will. We had an instance where a client had mentioned what he wanted done with what will deem a family business, and the intentions did not sort of align with perhaps what you think that the immediate family would think, but those are his express intentions for it. And this is one of the benefits of how a will is being distributed, because intentions are very, very clear. A will is also typically signed, right? And it's also signed in the presence of at least two adult witnesses. And why are you doing that? You're doing that by saying that when you're signing a will, there are two adults who can see that you actually signed this will and there were witnesses to that, and they have a portion where they witness. Please note that the witnesses are not required to look at the content of your will because they are private, but they are just there to witness that they saw you make this will. We go the extra mile by doing photographs and even having a video recording the testator signing as an overwhelming evidence in the event that anyone could see that. And it must also show that that person who made the will did not do it under undue influence, right? You were not coerced. You didn't have someone put a gun or a knife to your head and said, please write this will or see how it would. Proper execution is also required. Now, how does a will simplify the distribution process? Because of these processes, it's made a will very clear. The instructions are specific. Number two is that it also allows for the appointment of an executor. An executor is a trusted person who is appointed to oversee the administration of the estate and the distribution by the time the will is read in probate. This process also makes, avoid succession, which means that if someone dies interstate, a will be distributed according to the intestacy law of a particular jurisdiction. It can be shared equally among perceived individuals, and sometimes that may not be the intention of the owner of the assets before his demise. Another portion we want to see that makes it simple is that a will can cater for minors. So when you have beneficiaries, some are adult and some are minor. You're not going to distribute an asset and hand it over to a 7 years old child and say, these are your assets. They may not know what to do with it. So a will can create a trust that ensures that the asset is being invested or kept on behalf of the minors to take care of their immediate need, like educational need, medical needs, and other needs like that, until they get to an age where they can take possession of those assets themselves. A will enables you to do that, and it simplifies all of these processes. It will indeed simplifies the process of asset distribution by clearly defining what the assets are that should be divided. It reduces cost and those are tax. It looks for the most tax efficient way to ensure that the distribution is being done. It also reduces family dispute and possible litigations that can come out of this. I hope this helps and provides some clarity. Thank you.
Oh, yes, this has actually been really clear. Thank you so much for sharing. Let's keep our questions coming in. We'll have a question and answer segment in a couple of minutes. So please drop your questions in the chat box at the bottom of the screen if you're joining us on Zoom. And if you're on YouTube, please drop your questions in the comment section. Now, we have discussed wills, and Michael also mentioned the concept of trust. So we'd like to delve into the concept of trust a little bit. Over to you, Namdi. Can you explain what exactly trust is and what exactly makes it stand out as a tool in estate planning?
Thank you very much, Lauren. In estate planning, we discuss private trust. A private trust is a legal arrangement where the first party being the settlor, that is the original owner of the asset that is proposed to be used for the trust, transfers such properties, the title of that asset, to the trustee, who would have the capacity to hold these assets and manage the same assets for benefit of named beneficiaries. A trust is quite flexible, and part of what beautifies trust is that the terms that regulates the relationship between the trustee and the settlor as well as the beneficiary. The trust deed is well documented, enables parties to state what they want from time to time. Trust is quite beautiful, like I've said earlier, and part of the things that makes trust beautiful are the benefits. I mentioned flexibility, which enables you to change from time to time. My colleagues have also spoken about probate. A trust helps you avoid probate actually, because the asset itself has been transferred to the trustee to hold and manage. There won't be need to go to probate to get the appointment of the court or the authorization of the court to go ahead and administer the assets lawfully. A trust perhaps is the most seamless succession planning tool. So what that simply means is because the asset itself is with the trustee, you've directed around what the trustee should do, who should benefit from this asset, who should be the heir, who should take this asset, especially after the lifetime of the settlor. So really, it's seamless because all the trustee needs to do is to transfer the title which is holding, legal title, I must say, to the named beneficiary according to the instructions of the settlor. Trust also helps individuals who prioritize confidentiality in planning their estate. It's quite confidential, and trust enables you to protect the asset, especially from creditors. Trust helps you in tax planning because in the process of structuring your trust, we are able to involve tax planning experts who would then look at the asset, who would then look at the laws, who would then make recommendations around how to put the best structures to minimize the individual's tax exposure. And of course, part of the common benefit of estate planning, which is peace of mind. It really helps to know that you've put together your affairs during your lifetime, which you can benefit from, during your lifetime. And even when you're no longer in the picture, your beneficiaries are able to take without rancor, without conflict. And most importantly, persons you do not intend to be partakers of your hard-earned effort are stopped from being part of the process. And in United Capital Trustees, we are able to structure trust according to the specific needs of individuals. So this would lead me to talk about briefly some of the trust structures that we put together. we are able to put together a living trust structure, which the individual setting it up or the entity setting it up is able to be the primary beneficiary of such trust during his lifetime. And even afterwards, the instruction continues. We are also able to structure education trust, which is basically channeled towards education-related needs. Charitable trust is also something we offer that enables us to cater for your directives around charitable givings. And related to that is also endowment trust structures, which would focus on the use of the profits from the assets set aside in the trust to fulfill the various charitable needs. For politically exposed individuals or persons who prioritize avoiding conflict between their occupation and their assets, we also structure the blind trust. And as well as my colleague has also mentioned earlier, that trust can be born out of a will. So yes, we put together testamentary trust, which comes out of directives in a will as well, all together to give you seamless estate planning benefits and to also help you arrange your affairs during your lifetime. Thank you, Florence.
All right, thank you very much, Nandi. Thank you for speaking about the various types of trusts that are available even here at United Capital Trustees. Now, still on trust, Michael mentioned that as long as you're an adult, you can create a will, right? Does this apply to trust as well? I also like to think that there is a trust solution for everyone. So could you shed a bit of light on this?
Okay, thank you very much. Well, it's important to note that trust is crystallized using an agreement. So the necessities required to enter into an agreement still comes into play. It requires an adult really to be the settler of a trust. However, you can structure a trust having minors in mind. For instance, education trust could have the settler being an adult, but targeted at the children or minors, for instance. So yes, you have to be an individual having the capacity, particularly around the age to contract. But in a case where the child or minors are the focus, yes, an adult could stand in as their next friend or just for the sake of meeting the legal requirements.
Thank you very much, Namdi, for clarifying this. I mean, you mentioned a couple of different kinds of trust available. There's a private trust, living trust, education trust. I think my favorite is even the education trust, because looking at our theme for this webinar, which is next of kin versus beneficiary, understanding the value of estate planning. The whole essence of estate planning is to ensure that your loved ones are well taken care of when you are no more. This brings me back to, I think, a tweet I saw a couple of weeks ago where I saw someone posted and the person said something about his colleague who started out paying a certain amount of money, I think about 5,000 naira over 20 years ago, into a trust account. And right now, the child that they were paying, a child that an educational trust was created for, is currently in her second year in a Canadian university. So even if this has actually helped to set up that child for life, so it's really beautiful to see that a lot of people are taking estate planning seriously and ensuring that their loved ones, even while they are alive, are enjoying the benefits of this trust. So let's take it down to Nigerian policies. Recently, the Central Bank of Nigeria introduced a new law stating that, a new policy rather, stating that next of kin can claim funds in dormant accounts. So Dr. Sophia, taking it from your perspective as an expert in the field, could you shed some light on this new policy and what it entails for Nigerians?
Well, thank you. The policy is still new. It's a welcome development, but with mixed feelings. And so there's more work that needs to be done in the industry. Why do I say it's a welcome development with mixed feelings? because I was just going through decided cases. I mean, Supreme Court, Court of Appeal, all the cases that had gone to court that had to do with issue of next of kin, beneficiary, people that feel entitled, having conflict over one thing or the other. Now I've looked at the policy. What does this policy say? That once someone is dead after some years, a next of kin can apply to get retrieve that money. Now the question is, who is a next of kin? Well, I was explaining earlier on, I mentioned Section 49 of the Administration of Estates Law of Lagos State, for instance, that prioritizes who next of kin is now or who they are. Now you start with the spouse, the children, the parents, and then the siblings. And then even other laws says the closest relative. So when these people have been mentioned, your brother or a distant uncle can be a next of kin. If you are not in a town or where these people are not available, the next closest relative to you can be defined as your next of kin. Now, what comes to my mind with this policy for those that are listening is, who do you want to go through this kind of process? Because anybody can come, and there are decided cases that says that where a deceased dies intestate, all the beneficiaries, the next of kin, are entitled to get equally. So they all have equal rights. So who will be the first person to come? I'm beginning to look at the issues the CBN will likely get from this kind of thing. In the beginning, it might be easy, but after a while, watch it. There will be a lot of litigation arising from this kind of money. Because even when you have agreements in the process of probate, we see situations whereby it still lands in court, where some beneficiaries feel what they were given, they feel they should be entitled to more. And so while looking at this particular policy, what I want the audience to take home is, why don't we put things in perspective and protect our beneficiaries to say, I want A or B. I want this particular child or this particular friend to have this, and not leave it to something, an account or a fund being dormant, and the family and the beneficiaries to start thinking who to claim.
All right. Thank you very much, Dr. Sophia, for sharing your thoughts on the current policy by the Central Bank of Nigeria.
I've seen a lot of people going through, completing forms.
All right, Dr. Sophia, you're breaking up, if you can hear me.
Random names as next of kin. So the next of kin might not necessarily be.
Dr. Sophia, if you can hear me, you're breaking up.
Recover that money. Yes, according to the CBN policy, the next of kin will have to come with evidence, but we know what can go wrong. So it will not be a route I want anybody to try to wait to that. Is to plan your estate so that you don't have to go through that route. To state money in the bank should go to ABC. So, but for those that are already dead, yes, our audience know that they can take a chance at that, and you brace up with your evidence of relationship, your ID card, and you have documents to show, you can go and brace up. But it will be better if the family members or the close beneficiaries would come together to avoid potential conflict. Michael has initially defined who a next of kin and beneficiary is. There's a thin line between both of them because the next of kin are the legal closest relative. However, the deceased or the owner of that particular fund might have other intentions for the use of that money. And so this CBN policy is already there, it's fresh. We are waiting to see how things unfold. Thank you.
All right, thank you very much, Dr. Sophia, for sharing your thoughts on the new policy by the Central Bank of Nigeria. Let's keep our questions coming in. We'll take it shortly, and I trust we are getting value so far. So over to you, Michael. As a professional in the trusteeship field, what are your thoughts on this policy, and what implications you think they might have for asset distribution and estate planning in Nigeria?
All right, thank you, Florence, and thank you, Dr. Sophia, for shedding some light on this. Again, no one, well, speaking as individuals and businesses, have any control over government directives and guidelines that are issued from time to time. And indeed, a very laudable steps taken by the CBN again to address the mounting, sum of funds, under dormant account generally, and to say how we can implement it. And again, some of those things have already been proactively taken care of. Again, as you will see that the CBN actually oversees that money and placing unclaimed money into an unclaimed balance trust fund, which is a pool account and is now eventually invested in treasury bill and other securities. And what the guideline now says is that a next of kin, right, for an individual account, and whether it's a business account, the directors or the alter egos of a firm should step forward and bring claims, indicating that, look, this is a document that shows I am next of kin, and I am who I said I am. And if it's a company, bring particulars of directorships and other things and bring before them. This guideline says that a valid claim, when submitted, the principal plus the interest is returned to the claimant within 10 business days. Now, this is a very expedited process that is supposed to work in favor of everyone. The problem around it is because your next of kin is the next person to contact, and rightly so. And there are many, judicial precedents that states that your next of kin can actually manage an estate for the distribution to specific beneficiary, and does not mean that they necessarily are beneficiaries. A lot of us, maybe before you got married, you had an account, you used your younger brother, you used a friend, or you used somebody whose proximity was close to yours. And since that time, you've not updated it. And now the years has run by, you have a family now, you have dependents, or it's even a business and you had mentioned one or two other persons there or so. Without rectifying that, if a next of kin brings a proper claim within 10 business working days, they can access the fund in an account, both the principal and the interest that was invested in a treasury bill. The problem with that is that it is doubtful that that is the clear intentions of the owner of the fund in this case. So this is the way forward. We ask that be intentional about what you do. Do you have accounts? Even if you have a will and you have some account that was not mentioned in the will, through a codicil, an amendment is allowed so that you can specifically mention the account number and designate who it goes to. That way, you have directed it to a specific beneficiaries, and these directives will not, it will not be caught up under this directive. Number two also is that if you don't have one, this is the time to get very intentional, right? Because government directive comes from time to time, and sometimes government don't have the full oversight or possible consequences that could come out from this action. So how we safeguard ourselves is to be intentional about what we have, to be clear about how it should be distributed, and also to be specific about who our beneficiaries are and in what proportion they should take, whether under a trust when you are alive, under a will in the event of a demise. And those are our take around this, and say, look, be intentional around it so you don't get caught up by government directives and regulations. Thank you.
All right, thank you very much, Michael. Thank you so much. I think the key word from everything you've said right now is to be intentional about planning your estate. Now, for those of us who are interested in accessing estate planning services from United Capital Trustees, we're channeling this question to Nnamdi. How best can attendees get in touch with you just in case they want to sign up for any of our trust services? Please go ahead.
Okay, thank you once again, Florence. The first thing we say is that there is something for everyone. For the individual, we are able to plan your estate, plan your lifestyle, and also your succession plan is put together. For corporate entities, you can plan for retirement for your members before they access their pension benefit. So if you want to reach us, you can reach us via email. I will provide our email address. That is the first point to start the conversation, to schedule further meetings with you. Send us an email to trustservices@unitedcapitalplcgroup.com. You can also reach through the number 020-146-31130. I'll take that again, 020-146-31130. You can also call a branch by our website. I say branch like is a physical location at www.unitedcapitalplcgroup.com to see our other trust services. So when you reach out to us, we would write back to you, schedule a meeting, and start your estate planning journey.
Thank you for watching. If you're new to this channel, consider subscribing so you won't miss out any of our latest video.